Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. We're back in Stephen Macedo's New Right versus the Constitution today. Picking up where we left off, we're in chapter 2 now, the framers of the Constitution versus Judge Bork. We'd like to thank Cato Institute for publishing this, making it available. Go to cato.org and support the organization. I've already said what I think about Cato. It's a mixed bag, but they are worth supporting. They're a little squirrely on some topics. If you go to cato.org and you search Macedo, you're going to find the New Right versus the Constitution. I'm showing it on my screen right now. Just clicky little wiki, and the book is free to download. It used to be that you could download a PDF, uh, but they don't do that anymore, I don't think. So I have a PDF. Well, maybe they do have it. You can download the ebook onto whatever e-reader that you have. I don't really use my e-reader because I don't like ebooks at all. I do have it downloaded just because I wanted to see if it worked. So it comes up on Apple Books or whatever. But I got this back when they had the PDF. So that's what I have in my hand right now, printed out. And it's a good volume to have. I think you should have a hard copy of it, but of course, if you don't have a printer or you don't have access to the PDF, then I just will warn you that the pagination on the PDF is different than the ebook, and the ebook is not the same pagination as I'm going through it. So I'm just going to use the PDF pagination, the old school. Of course, the book will have the PDF pagination as well. If you get the hard copy, if you can find a hard copy of it. We're going to do a fair use of this and make a transformative reading. We'd like to thank Stephen Macedo for writing this and Cato Institute for publishing it. Go to cato.org and support the organization, download it, and you can sign up for their updates, and they send you emails about what's going on, what they're covering on their podcasts, so on and so forth. Their deregulation, their regulation magazine uh, is excellent. They have an unintended consequences podcast that I follow, which is also very good. And so I'd recommend that. Invocation of the intent of the framers of the Constitution has long been a crucial element in the conservative attack on an active judiciary. So starts Stephen Macedo in his chapter 2. Okay. Bork is unequivocal. The framers' intentions with the respect to freedoms are the sole legitimate premise from which constitutional analysis may proceed. Hmm. Activist judges, say conservatives, willfully ignore the intentions of the framers, insert their own preferences into the Constitution, and in doing so, perpetuate limited coup d'etat. The evocation of the framers' intentions has great political appeal. Attorney General Edwin Meese has now made it the centerpiece of the Reagan administration's jurisprudence. Here's a block quote. What then should a constitutional jurisprudence actually be? It should be a jurisprudence of original intention. This belief in a jurisprudence of original intention reflects a deeply rooted commitment to the idea of a democracy. It has been and will continue to be the policy of this administration to press for a jurisprudence of original intention. In the cases we file and those we join as amicus is how they originally said it. We know that because we found the CDs in Pompeii, so we can hear how they said it. They're actually 8 tracks because it's so old, but They say amicus. We will endeavor to resurrect the original meaning of constitutional provisions and statutes as the only reliable guide for judgment. If every phrase in the Constitution were as easy to interpret, sorry, that was Edwin Meese. That was a block quote from Edwin Meese, 1985. Famous. Should have said that. I was thinking that in my mind. I probably should say it. And it's in the footnote. So back to Macedo, bottom of page 7. If every phrase in the Constitution was easy to interpret as neither shall any person be eligible to the office of president who shall not have attained the age of 35 years, unquote, enforcing its provisions would be an almost mechanical process. Fair enough. Fair enough, Macedo. Macedo, I'm with you, bud. I'm with you so far. Keep going. But even the First Amendment, whose words appear to speak plainly, Congress shall make no law respecting an establishment of religion, okay, abridging the freedom of speech or the press, raises extremely difficult problems of interpretation. The Constitution places a high value, if not the highest value, on democratic accountability. And so we can be confident that part of the purpose of the constitutional guarantee of free speech is to protect free and open debate on political matters. The First Amendment also protects, after all, the rights to assemble and to petition the government for redress of grievances. When the text of the Constitution is uncertain, help can be sought in the overall structure of the document, the relation between its various parts, or in the nature of the institutions the Constitution establishes. From this more general examination, we can conclude that the First Amendment already certainly must protect political speech. I'm going to take a drink of water. I'm going to mute it. Back. You still with me? Page 8, middle. But certain forms of political speech may conflict with government's most basic purposes, such as maintenance of national security and public order. There are some clear cases. For example, while citizens have a constitutionally protected right to criticize the government, although even that was not always obvious, witness Alien Sedition Acts, they do not have a right to publicize the sailing times of troop ships during wartime. But between the easy cases lie many hard ones. Do people have a right to oppose the constitutional order itself? Can people advocate for forcibly overthrow? Can people advocate forcible overthrow of the government? Can scholars publish and professors teach doctrines that public authorities consider dangerous to the established order? I will say this really quick, okay, because this is brand new, okay? Macedo has published a book just last year on the lockdowns and the response to the scamdemic and the government censorship project, which we're still censored on YouTube. I'm still censored on YouTube. Republican professor has 2 videos the Biden administration pressured YouBoob to take off. They're still off right now, today, 8 January 2026, years after Jesus. Macedo, to his great credit, has utterly obliterated that entire Democrat project and any Republicans that went along with it. It was mostly Democrats. We're going to get to that because my professor, Joseph Bissett, excellent professor, hard ass, love him. He was on my dissertation committee. Joseph M. Bissett wrote a wonderful book review of Stephen Macedo's new book on the COVID response in the Claremont Review of Books, winter 2025-26. We're covering it on the podcast, but just not today. I just wanted to point out that's coming up. Macedo has great street cred. He's wrong on the definition of marriage. Totally wrong. Totally wrong. But he got the response to COVID right, and good for him. And I'm glad he's on our side, and we need friends like that. And this is a mixed bag here, but we need to go through it. He's got a lot of great stuff in here. There's some stuff that's a little bit squirrely. We're going to try to discern what's worth keeping and what's not worth keeping here to the best we can. Um, so he's just suggested that the First Amendment is difficult. It's not as easy as the age requirement for the president. When you're interpreting the Constitution, not everything is as obvious as the provision of the age requirement for president. Like, for example, he just gave the First Amendment. How are courts supposed to go about their business interpreting these things? And remember, he's bringing up Meese and the Reagan administration. Reagan and Meese were bringing up, hey, original intent, dude. We got to go back to the original intent. So he's gonna pound the original intent thing. And because of his criticism and others in that camp, Republicans were forced to redefine what they meant by originalism. And so there was a development from originalism of original intent to original public understanding, largely because of criticism like this. Okay, so keep going here. Of course, the First Amendment does not specify that only political speech is to be protected. It says simply speech. But what does speech include? Words that offend or libel? Words that some find obscene? Printed material that a majority of community considers pornographic? Oh, there you go. He's a little squirrely. Can sleeping in a public park or exotic dancing be forms of symbolic speech? He's going Democrat. He's going Democrat. Is corporate advertising a form of speech? In deciding these hard cases, judges have to articulate the basic principles and fundamental values that give substance and specificity to broad constitutional guarantees like the First Amendment, page 9 at the top. The many difficult questions raised by the First Amendment are also extremely important. Although particular cases may affect only a handful of people, the principles articulated and applied by the Supreme Court and lower courts help determine the powers of legislative majorities and the rights of minorities. These rights and principles often become part of our political culture, determining in part the sort of regime we live under and the kind of people we become. I'm going to take a sip of green tea. I'm going to pause it or not pause, but you mute it for a sec. Back. While the First Amendment raises a host of difficult issues, it is relatively straightforward compared with the truly majestic generalities that must also be interpreted and applied by judges. Witness the expansive phrasing of the 14th Amendment. Here's a block quote. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. That's end of the quote. It is no easy matter to decide what these important phrases require. And here, the Constitution's structure provides some assistance. Since 1925, the Supreme Court has given substance to the 14th Amendment by incorporating into its general phrases the more specific guarantees contained in the first 8 amendments included in the Bill of Rights. This court has sought, in Justice Cardozo's words, for those principles of justice so rooted in the traditions and conscience of our people as to be ranked as fundamental. That's from Palco versus Connecticut, 1937. I'm going to let you look at the title for a while I read, okay? Again, you can download this, cato.org, right there. You can just download it, and it's free. Cato has published this book in 1986, and it's free. So thank you, Cato, and thank you, Steve Macedo, for writing this. Okay, so incorporation, fundamental rights, Palco versus Connecticut, 1937. However, referring to other parts of the Constitution may not be sufficient when interpreting a phrase like due process. Yes. Turn the page 10, due process of law, which has a historical resonance, recalling Runnymede and the Magna Carta. As hard to interpret as the 14th Amendment is, how other parts of the Constitution have been deemed so obscure as to wholly defy judicial interpretation. Consider the Ninth Amendment. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Which other rights do citizens retain under the Constitution? The Ninth Amendment sets a moral question for constitutional interpreters. What rights do people naturally have and retain under the Constitution? Good, good, Macedo, good. It is disappointing, but perhaps not surprising, that the Supreme Court justices and other constitutional interpreters have typically fled from the hard moral judgments called for by the Ninth Amendment. Now, Hadley Arcus is loving this one. How, then, are judges to decide what the Constitution requires in hard cases? They begin with the text itself and seek to understand not only the words, but the structure of the document as a whole, the nature of the institutions it sets up, the powers and rights it enumerates, and the principles and purposes implicit in these words, structures, institutions, powers, and rights. Supreme Court justices also have to contend with a 200-year accumulation of thickly textured constitutional case law, interpretations that have helped give substance to the Constitution in previous cases, and that have been relied on by lower court judges, and that may have become part of the public's understanding of our fundamental law. Received authoritative interpretations and practices deserve to be taken seriously. And yet, the Constitution declares itself to be supreme and requires that judges take an oath to support the document itself rather than past judicial interpretations of it. Very good. The Supreme Court and any other constitutional interpreters may decide that an established line of interpretation was mistaken. While text, structure, implicit nature, principle, purpose, and precedent are always helpful guides in constitutional interpretation, they will not suffice for many tough issues. A justice might, turning the page, page 11, a justice might doubt. You have to look at me for a while. Sorry. I know. A justice might doubt, for instance, that the Ninth Amendment has been taken seriously enough. He might suspect that people have fundamental rights that are being ignored. But how does he decide what these rights are? Besides using text, structure, and precedent, a justice considering what rights Americans have may turn to our political traditions and to moral philosophy. Another sip of green tea. Partisans of the new right seek to constrain the judicial search for constitutional meaning. They insist, as Richard Nixon once did, that Supreme Court justices should be strict constructionists. They must be prepared to enforce the law as it is and not twist or bend it to suit their own personal political convictions. As Bork puts it, quote, the judge must stick close to the text and the history, unquote. These guidelines appear to be innocent enough, but appearances sometimes deceive. By admitting only those rights specifically envisioned by the framers, the new right hopes to straitjacket the Constitution's broad protections for liberty by precluding judicial reflection on the Constitution's more general purposes. By sticking to strict constructions and historical intentions, judges may judges say conservatives remain within their limited and precarious mandate to review legislative acts in light of the Constitution. The case for strict constructionism and historical intent is supported by particular notions of democratic authority and individual liberty that are considered later in this book. Here, it is worth considering in some detail the hurdles that must be cleared by the jurisprudence of original intent, hurdles that are sidestepped by Bork and Mies. So here he's criticizing Republicans in the 80s under Reagan, because Bork was Reagan's nominee to the Supreme Court, and he was opposed by Democrats. Kennedy eventually made through. Kennedy. Mies was um, Mies was actually confirmed by the Senate as Attorney General. Had Bork gotten in there instead of Kennedy, there probably would not be marriage redefinition from the Supreme Court like we had in 2013 and 2015. So that was a kind of a big deal. Bork probably wouldn't have done that, which is why Macedo is criticizing him, because Macedo likes the redefinition of marriage. That I mean, we found that out later. Of course, we didn't know that at the time. Of course, I was in sixth grade when this was published, so I wasn't quite following it yet. Although I was following the Oliver North stuff. That was the first time I really started paying attention to politics was Oliver North. Um, so first of all, whose intent is to count as original and authoritative? Again, remember he's going after original intent, the subjective intent. And Republicans have strayed from that. They don't defend that anymore. Back then, they were just kind of bulldozing through originalism, and this was their first try. And Macedo jumped on them, and then they had to in the Socratic dialogue, they had to come up with a response. They came up with a response with public understanding, original intent of the originalism of public understanding. It's not subjective intent; it's how it would be understood to the public. But Macedo is responding to the first iteration, the first wave of originalism, if we can call it that. So this is his. going after that. First of all, whose intent is to count as original and authoritative? Who were the framers? And how are we to make sense of the idea that this large and disparate group had a unified intent? Should the intentions of all the delegates to the 1787 Constitutional Convention in Philadelphia be counted equally? Or, and here we turn the page, or page 12, should the intentions of those who took a leading role in the drafting of the text count for more? Given the rather spotty records, um, one would need to rely on the intent of the leading advocates. But clearly, such individuals as Alexander Hamilton and James Madison were proponents of particular and, as it turned out later, different theories of the Constitution. Well, that's right. They did go head to head. After a while, they did go head to head. That's true. I'm going to take a sip of water. Yep. The first political parties started with the people that defended the Constitution and the Federalists. Okay. There was the first political split in the Washington administration. Actually, the first political parties were probably the Federalists versus Anti-Federalists, I think. That's my opinion. And you can see that in the title of the book, The Federalist. That was one particular party, the one that was for the Constitution. Okay, let's keep going. Um, it was, of course, ratification. Hmm, hold on. Recording in progress. All right, I'm back. Sorry. Page 12. Um, it was, of course, ratification that gave the Constitution the force of fundamental law. So why should the intentions of the Philadelphia delegates be counted, but not the intention of participants in the state ratifying conventions? Scholarly proponents of original intent, like Raoul Berger, seek the intentions of those in Congress who proposed the 14th Amendment rather than the more elusive but more pertinent intentions of those who secured its ratification in the states. Fair enough. I mean, fair enough. Yeah. I I I I don't mind this. I love this criticism here. Yeah, it's good because you're really talking about the meaning of a text, and the same would go for um, other documents. It's a little bit different with the scriptures, for example, because the intention of the author would be more important because it's not ratified. It's not a law. It's not voted on in terms of its authority. Its authority is in who wrote it and under what inspiration, not what people thought about it later. But that's a issue of canonicity, and we can talk about that at another time because it is very interesting, similarly related to this. Okay, let's continue there. Should the intentions of those who seem to have misunderstood what was being voted on be discounted? Perhaps, but no such judgment can be made without some independent conception of what the Constitution really means. And that is exactly what the conservatives think we do not and cannot have. In short, simply deciding whose intent counts proves to be quite difficult. It requires an elaborate theory and considerable historical research. The second problem is to decide what counts as evidence of intent. William Kroski undertook prodigious research in the unpublished correspondence and manuscripts in his quest for the framer's intent. Raoul Berger, on the other hand, considers only the public published record of the passing of the 14th Amendment, the Congressional Globe, in trying to determine the intent of the framers of that crucial part of the Constitution. Yet, and here we go to page 13, yet records of congressional proceedings may have been edited, as is today's congressional record. As for the Constitution itself, no official record of the closed proceedings in Philadelphia was ever published. This is a good point. An incomprehensible oversight if it had been expected that future interpreters would be guided by the framers' intentions. The official record of the convention recorded motions and votes, but not speeches. James Madison's unofficial account of the convention, reconstructed from his notes, was published posthumously in 1840, after everyone who had attended the convention was dead. Mies, however, in defending his jurisprudence of original intent, claims, quote, the disputes and compromises of the Constitutional Convention were carefully recorded. The minutes of the convention are a matter of public record, unquote. Even if we were to accept Madison's account of the convention as authoritative and complete, we would still need to confront the fact that public statements often do not reflect actual intentions. How would we distinguish between genuine evidence of intent and the delegates' posturings, rationalizations, and statements for public or scholarly or historical consumption? More basically, just what are intentions in this instance? Are they the framers' expectations as to how particular provisions would be interpreted, or are they the framers' hopes? And what of the intentions of those legislators who did not speak? Let us suppose that the first two hurdles have, against all odds, been cleared. We have decided whose intentions are to count and what is to count as evidence of intent. But after all this labor, we find that the intentions of those involved in the long and arduous process of proposing and ratifying a constitutional amendment, keep going here, page 14, are complex and conflicting. We find that vague and general language cloaks disagreement and constitutes a delegation to future interpreters. Conservative proponents of the jurisprudence of original intent ignore the crucial distinction between language that is ambiguous, admitting of different but specific meanings, and language that is vague or general. As John Hart Ely argues, quote, the choice of a general term should, in the absence of contrary evidence, be assumed to have been conscious, unquote. Indeed, Mies implies that we should accept the Constitution's general phrases as written and interpret them as such. But he fails to understand that in so doing, he undermines his own reliance on specific historical intentions. Quote, those who framed the Constitution choose their words carefully. They debated at great length the most minute points. The language they chose meant something, unquote. That's from Mies, the same address, 1985. To rely on specific but unstated intentions is to ignore the obvious generality and sweep of the language actually chosen. The conservatives would substitute narrow, specific intentions for broad terms that became fundamental law. The search for specific intentions represents not reverence for, but a misunderstanding of the project of the framers. When it comes to defining constitutionally protected freedoms, conservatives claim that judges should protect only the specific sorts of activities the framers had in mind. Judges are bound, they say the conservatives, to enforce not their best understanding of the general concept chosen by the framers, but only specific examples of the general concept that some framers may have had in mind in circumstances very different from our own. However, the framers of the Constitution were perfectly capable of being specific when they wanted to be. They said, for instance, that the president must have attained the age of 35 years, not the president must be mature. I'll mention that the pro-life, pro-choice debate, though, would possibly bring some unclarity to what is meant by how old you are, starting from birth or starting from conception. Most pro-lifers, alleged pro-lifers, will use the pro-choice language of from birth, which I think is very strange. And as Justice, back to Macedo here, page 614, bottom, 15, top, Justice Frankfurter pointed out in Adamson versus California, what was voted on at each stage was the proposed language or amendment, not the speeches. Surely there is no reason to suppose, as do the conservatives, that judges are obliged to read the framers' sweeping phrases narrowly in light of specific unstated intentions, given that the framers could have used more specific phrases but chose not to. Again, we are in The New Right versus the Constitution, 1986, published by Cato Institute, written by Stephen Macedo. We're on page 15 now, and let me see how far we have to go here, how far we can go today. We've been going for a bit. I think I'm going to break this up into two different sections here, just depending on how far we have. Okay, so we go to page 23, and we started at page 7. So we have, if we're on page 15, we went about 8 pages or so, and then we have about 8 pages left. So that's about half. We're about halfway through page chapter 2. Okay, and I think that might be a good place to stop here for today. Um, let me see here. Yeah, I think I'm going to stop there for today. We stopped at the end of the first paragraph on page 15, but chose not to. And then the next paragraph starts, the 14th Amendment, for instance, requires that no state shall deny. Okay, so we'll start there next time on page 15, 15, 16, 17, 18, 19, 20, 21, 22, 23. That's 9 pages. 7, 8, 9, 10, 11, 12, 13, 14, 15. That's 9 pages too. Let me go to the end of page 15. Okay. The 14th Amendment, for instance, requires that no state shall deny to any person within its jurisdiction the equal protection of the laws. Should judges be confined to the specific kinds of unequal protection that the framers of that amendment might have had in mind? That is, if many of those responsible for the 14th Amendment expected, foresaw, or hoped that it would prohibit racial discrimination in common law, but not other forms of invidious discrimination, are judges bound by that concrete, unstated intention to allow all other forms of discrimination, as Bork has claimed? Judges could instead seek and apply the morality, sorry, Judges could instead seek and apply the morally best understanding, the morally best understanding of the principle and values that gave substance to the sweeping phrase, the unequal protection of the laws. Judges seeking the morally best meaning would not engage in historical research designed to resurrect the intention of the persons long dead, as the new right would have us do. Rather, they would seek the meaning that makes equal protection the most worthy value or goal consistent with other values and goals in the Constitution. There are many reasons for preferring the latter alternative. Constitutional principles must be applied to circumstances the framers never envisioned. Even when institutions persist, the passage of time may alter their status in society. Public schooling is a good example of that. Further, it may be that particular framers at the concrete level inadequately understood what the equal protection of the laws actually requires. The supremacy, page 16 now at the top, of the Constitution as written, general sweeping phrases, and all may require specific judicial measures that the framers of the particular clauses did not contemplate. Finally, the best reason for even acknowledging the supremacy of the Constitution is the document's conformity with our best understanding of justice. By engaging in moral reflection rather than historical research to complete the meaning of the Constitution's difficult passages, judges help justify and vindicate the Constitution's moral supremacy, helping to realize the Constitution's moral aspirations, and help to ensure that we will be governed by more than the will and preferences of the most powerful. Okay, so that's page 16. That's the end of the first paragraph at page 16. Let me make some comments here. I've taught both constitutional law and ethics at the college level, and notice this is a battle here between which discipline is in the front seat for constitutional interpretation. That is to say, is it ethics for these general and vague phrases of the Constitution? Uh, is it moral reasoning? Or is it historical research? And are those pitted against each other? Um, the natural law is morality, that's for sure. It's the moral law, for sure. But there's a historical understanding of that that would be different in, for example, a biblically literate and informed society, one that believes in God. How do you keep God out of the moral reflection thing? Do you want to keep God out of that? um, if so, why? And I know from firsthand experience teaching analytic philosophy, the analytic philosophers in the 20th century, the history of analytic philosophy is trying to talk about reality without God, without without getting the camel's nose under the tent of a purely natural world, because that those were the assumptions of the philosophers. They were atheists, they're secular humanists. A lot of them, some of them are Marxists. And I mean, there are moral philosophers that defend the most barbaric and horrific things, and they're totally clueless. They think they're progressive. They think they're on the cutting edge, and they're not. They're vapid, and some of them, like for example, Richard Rorty, he's lost his mind. I mean, really smart guy, but he's crazy, you know? So what about that? And definitely not a Republican, by the way. How many Republicans are there in the moral philosophy departments? Just go to Boulder, knock on doors, just look at what they have on their walls. Good luck. So that you can understand why the Republicans will be very hesitant to give these provisions of the Constitution over to those people. No, not a good idea. You're basically letting the Democrats run wild. Thanks for joining me on the Republican Professor podcast. I've been your host, Dr. Lucas J. Mather. It's 8 January 2026, years after Jesus. We've gone through the first paragraph of page 16 in Stephen Macedo's New Right versus Constitution, chapter 2. Chapter 2 is styled as the framers versus Judge Bork. And we're going to continue with chapter 2 when we return in this series next time. And I'll see you next time. Okay? Take care. It's Thursday.